Okay, looks like it is time to kick things off. Welcome everyone to the Orange County Clerk of Courts Legal Matters Forum, and this is on evictions and an evictions update during COVID-19. I'm Dane Weister, and I'm the Communications Director here at the Orange County Clerk of Courts. Thank you for joining us. We hope the information that we provide here this evening is going to be very helpful to you, and it is very timely, especially in the times that we are in with the evictions process and with some of the moratoriums and the assistance. Deadlines are quickly approaching. So during the presentation, you'll be able to submit any questions you may have, but we ask you to submit it through the Q&A function that's at the bottom of your screen. And in there, you can type in your questions. There's no reason to raise your hand, type in your questions there. And at the end of our webinar, we're gonna talk through those questions and help provide answers verbally so everybody can hear those answers and questions. Just submit your question through the Q&A function. There'll also be a survey to fill out at the end of the presentation. So we ask you to please look for that at the end. That gives us great feedback. And this webinar is being recorded and will be posted on our website at the clerk's office website and on our social media channels. So now I'd like to introduce to you your Orange County Clerk of Courts, Tiffany Moore-Russell. Tiffany.
Thank you, Dane, and good evening, everyone. And I want to thank you all so much for being with us this evening. We know this is a timely and critical topic to discuss in today's environment. This webinar discussion will give you an update on the Eviction Diversion program. We're going to discuss the legal process as well as provide you with information regarding your legal rights. One of my office's strategic priorities is access to justice, and I created these forums as a way to provide service to the public and provide information for you to be able to have information regarding your right when it comes to various legal issues. So before we get started, I do want to take a minute to acknowledge and thank my staff who worked really hard to bring this webinar to fruition. And I want to thank our panelists who thought it not robbery to take time out of their busy schedules as well as in the evening to be here this evening for this webinar. So first I want to thank the Chief of Staff to Mayor Jerry Demings, Roseann Harrington. Thank you for joining us this evening. Of course, you always know her. She always gives her time to be on our webinars, is my Self-Help Center and Family Services Operations Manager, Attorney Roberta Walton, is with us this evening. And then one of our fabulous judges here in Orange County, the Ninth Judicial Circuit, from Court Administration, and our judge, the Honorable Judge Eric DuBois. And lastly, but of course not least, from the Policy Perkins Bar Association, one of our attorneys here in the community and a good friend of mine, Attorney Andre Young, is with us as well. So again, I want to thank the panelists for giving us their time this evening, their knowledge, to be able to continue to share and educate the public. And for tonight, we're going to talk about eviction. So I hope you find this information helpful and valuable as we begin to continue to navigate these very difficult times. So with that, again, I thank you for joining us. And Dane, I give it back to you.
Great, thank you, Clerk Russell. So without further ado, let's jump right into the heart of this legal forum and the information everybody's looking for. First up, we have the Orange County Mayor, Chief of Staff, Roseann Harrington, who has all the latest information on the Orange County Evictions Diversion Program. Roseann, take it away.
For having me here this evening. It's a pleasure to be here. Orange County is very concerned about our residents and their ability to stay in their homes. And that's why in August of this year that Mayor Demings and the Board of County Commissioners approved the Orange County COVID-19 Eviction Diversion Program. And it's very important that we work together with landlords and tenants to keep people in their homes. And so this program is unique. We're not sure there's any other like it in the United States. And we did work with Clerk Russell and Judge DuBois and the Bar Association, Orange County Bar Association, Legal Aid, and Community Legal Services to come up with a program that was user-friendly and allowed both landlords and tenants to apply for the program. So I'm going to run through some slides and tell you a little bit more about the program and where we stand to date. Just give me a minute to upload. Here we go. All right, so as I mentioned, in August of this year, we allocated about $13 million. We started out with $20 million and then we brought it down to 13 million, because what we found was that there were still some folks who thought that the eviction moratoriums were going to be continued, or there was a little slow getting started. But we do have $13 million that we budgeted in this account. We've allocated about 6.5 million and we have about 6.5 million left. We have to spend the money by December 30th. So if there is anybody in danger of eviction, I'm telling you, you need to apply now, because we have to cut off the applications December 16th, because we have to be able to process them and get the payment out by December 30th. The tenant must be in imminent danger of being evicted. This is not a rent relief program. We do have an individual and crisis assistance fund for that. This is designed for people who are at least 2 months in arrears in their rent. You must have a documented COVID-19 impact, which could mean that you either lost your job or you had your hours cut. Or if you own your own business, is that you just haven't been able to open or run your business. Applications are done on through an online portal that you can track the progress. And as I mentioned, you have to be 2 months in arrears in rent. Payments are sent to the landlord directly. And we've come up with an innovative partnership with the Orange County Bar Association that administers this program. And they work very hard between the landlords and the tenants to try and match them, and so that they can move ahead and find a reasonable outcome or settlement to arrear situation. I'm just going to go ahead now and give you some of our program highlights, the results so far. We've had 5,293 landlords apply or submit applications for the program. And we've had 5,190 tenants do a pre-screen. So let me explain this, because it's really a landlord-driven program in that the landlord gets the funding, but the landlord and tenant have to agree. And so a landlord can apply through our website, which I'm going to give you the link in a few minutes. And they move through, they get a case number, and then an invitation is sent to the tenant to fill out an application. If the tenant applies, they go through a pre-screen to make sure that they qualify. And there are some income requirements, and then you do have to show a COVID impact. From there, if the tenant applies, an email is sent to the landlord, who then has to opt into the program. And so far to date, we have been able to assist over 2,000 families, and we have allocated, or we have processed $6.5 million. That's an average payment amount of $3,132. And interestingly, that's about 3 months in arrears. And the average household size is about 2.5. Like I said, we've had $13 million budgeted, so we have about 6.5 minutes left. So if you're interested, please apply as soon as possible. As far as where we have seen applications come in from, as you can see from this map, they have come in from throughout Orange County. It's really been amazing that it's been widespread, and we're pleased to see that. Now I'm going to go over some helpful hints. And if people would do all of these things, I can guarantee you your application will move much faster. So first of all, if you have any questions, call 311. That's Orange County's emergency number or information number, where somebody can direct you to an individual that can answer any questions you have regarding eligibility. We ask that you review all required documentation, the list prior to applying, so that you have everything pulled together. So when you go to sit down to apply, you have all the documentation. What we find is with some of these applications is they're missing a document. So then the processor has to email back and forth, and it just takes a lot of time. For tenants and landlords, you have to always make sure that that case number is on your applications. This is also how you can track your status. You can use that and you can see where you are in the process. Now, for the tenants, There's 4 documents that are required, and you need to make sure that they are all signed. And there are some that require witnesses, and because you're going to have to verify who's in your household. And so we ask that you have all that taken care of before you sit down to the computer to start working. You are going to need to upload the full lease, and the tenant's going to have to do that. The landlord can't do that. And again, this is for your own good. We want to make sure that what the landlord is saying you owed is consistent with what your rent is, what your lease says. And that's what this is for, so that we can make sure the goal here is to pay off your arrears. Applicants can receive up to $4,000. And so the way we decide how much money you get is based on, it's a max of $4,000. And we're finding that most are coming in around $3,100, but you can receive up to $4,000 in arrears paid. And the goal here is to pay all that off. Pay off your arrears so we can get you on firm footing so that you can move forward and focus on the future. We do need you to have a photo ID, and we want you to make sure that you upload it so that we can see the front side of the ID. Again, we have to track this, who's applying. Now, on the landlord application, make sure that the basic rent amount is in arrears. And we've had a lot of fees added here and there. We just need, that's why the lease is important. We need clear documentation on what was the basic rent, not late fees and garbage fees and things like that. And the last, but certainly not least, if you are a landlord, your W-9 needs to match your application. So when you have a W-9, if you are a business, what you have reported to the IRS, it's on your W-9, that name needs to be how you apply for the program. We have found one of the biggest problems is we get all the way to the end and then the application doesn't match the W-9, and that takes time to process. Again, we want you to move through this as quickly as possible. And last but not least, this is the website where you can apply for the Eviction Diversion Program. And with that, I will turn it back to you, Dame.
Office, the mayor's county office, and we appreciate, okay, so I think I was muted, so hopefully you're hearing me now. So thank you, Roseann Harrington with the Orange County Mayor's Office, Chief of Staff, for the insightful information on the Evictions Diversion Program. So again, the deadline is coming up to apply. So if you're looking to get relief or try to get relief funding through the diversion program, make sure you apply very soon, as soon as possible. Now, if the eviction diversion program is not something that will assist you or work for you, then it's helpful to know more about the court process, of course, right? So up next in our forum is our Family Division and Self-Help Center Manager, Roberta Walton, to share with us the evictions filing process here at the clerk's office. Roberta.
All right, thank you so much, Dean. And good evening, everyone. It's such a pleasure to join you again to talk about a very important subject matter, the legal process as it relates to coming to the clerk's office and filing for a formal eviction. So because I know there's other speakers that have to speak, and I have a presentation that includes a lot of information, I'm going to jump right in. Okay, so here we go. Again, eviction filings during a pandemic, because again, not as if the overall process is a little different, but things are just a little bit different in the country, in the world. And certainly they are also a little different when you come to file for a legal for any legal action right now. So just wanted people to really kind of understand that, albeit, yes, we are in the middle of a pandemic, but the courthouse is still open. And so we are still doing business. And up until probably about the first part of October, there was actually a moratorium here in the state of Florida issued by our governor that said if it was due to the pandemic, that no eviction filing could be adjudicated and filed and entered in terms of a final judgment of eviction. You could file it, but it couldn't go through the entire process. That was lifted at the beginning of October, which then started a CDC moratorium. And that's the reason why the governor lifted the statewide moratorium, because the CDC issued one on a federal level. And I wanted to share these steps with you relevant to the CDC moratorium. To be eligible, you must either earn less than, gosh, I can't see all of my presentation. That's all right, I'll read it. To be eligible, you must either earn less than $99,000 a year or $198,000 for couples, have received a stimulus check, or have been exempt from paying income tax in 2019. So that's number one when it comes to wages and income for eligibility. You must also, if you show that you've been struggling to pay your rent, and you need to sign a written declaration and deliver that to your landlord in order to justify the fact that you've been struggling. Before, it was enough to say, to come down to the courthouse and file something if eviction had been filed against you, and say, hey, it's due to COVID-19. But with the CDC moratorium, this is extremely important. You must fill out a written declaration showing that you have been struggling to pay your rent, and that must be served upon your landlord. In addition to that, the CDC moratorium, it doesn't change any local protections. It certainly doesn't end the fact that, or in your obligation to pay rent. That's still there. It just stops the process from happening in terms of a final disposition towards you, and a writ being issued where you have to actually move. Okay, and I'm saying writ because I know a lot of people don't understand it, but that's another document. We're going to go through each steps. But before we get there, I wanted to show you a little bit of what that declaration looks like. We have copies of this declaration at the Clerk of Court's office in room 340. If you need one, feel free to come down to our office and retrieve a copy. You can also Google a copy online by simply Googling the CDC eviction moratorium. What is also very relevant as it relates to this moratorium, and I think Roseann talked a little bit about it, is that it sunsets on December 31st. So the moratorium is from September 4th through December 31st. And if you issue this declaration to your landlord, it is only eligible for that time period, September 4th through December 31st. So if you had a hard time paying your rent in August, this CDC moratorium won't apply to you because it's from September 4th through December 31st. So let's talk a little bit about what it means and what exactly is an eviction. An eviction really is, again, a legal action when a landlord is forcing a tenant to move out. And there are several different reasons, and those that we're going to talk about this evening, of a landlord saying, I want this tenant to move out of my house, and I would like to garner possession back. So that means take back possession over the home, because when you are a tenant, you have legal possession of that house or of that dwelling unit. And that's what's important, because we have a lot of people to come down to the clerk's office and say, my landlord came, knocked on my door and told me I had to get out. And then they changed the locks. Or they gave me a piece of paper and told me, it was a note telling me I needed to get out. Keep in mind, an eviction can only happen through a court order. Okay, you cannot simply knock on someone's door and tell them they have to release possession. A landlord, even if they own the property and you are simply leasing that property, and if there is a violation, as if you've not been able to pay the rent, they still have to go through a legal process in order to get you out. So to legally evict a tenant, you first must be put on notice. So you must receive a notice from the landlord saying whatever the violation is, and the lease violation. It could be non-payment of rent. It could be a non-compliance of, of one of the elements of the lease agreement. It could simply mean, I'm not going to renew your lease agreement, and I would like for you to leave. But you still must receive notice in all of those occasions. And then a lawsuit must be filed after notice is issued, and a copy of that notice must be attached to the official complaint for eviction, and that would be filed through the clerk of courts at one of our offices, and we have multiple offices throughout Orange County. Once the lawsuit is filed, that simply doesn't do it. You still must go through a court process, and a court order must be obtained, and that court order must be signed by a judge. Still not over. Even if you have a final judgment for eviction, if you refuse to leave, that landlord must then go back down and have a writ of possession entered by the clerk of court and served on the tenant at the property by the sheriff's office. Okay. So there are a couple of different steps in order to go through every element of an official eviction, a legal eviction. And so what I see a lot is people coming down saying this happened, and a lot of elderly people, somebody gave me a letter and told me I had to get out, and they just leave everything. Know that there are several different steps, and the clerk of courts has assistance if you are attempting to represent yourself, and or if you're attempting to do it, to file the eviction on your own. So here's the paperwork that we actually sell. This is the first couple of pages of the documents, and it also lists the 5 locations throughout Orange County that you can actually file an official eviction complaint. We accept them, of course, at our downtown office, which is at the Orange County Courthouse, within the Civil Division, which is in room 350. If you are attempting to represent yourself, whether it's a landlord and or a tenant, you can come to our self-help center, and that's in room 340 at the downtown courthouse, or you can go to one of our satellite offices. We have 3 branch offices, one in Ocoee, Apopka, or Winter Park. But here's the paperwork. We offer this paperwork. It is for sale online on our website as well, but it shows you all of the steps and all of the forms. We provide these forms here for you, and we even have some information right now through the end of the year regarding the Eviction Diversion program that Roseann from the Office of the Mayor just discussed. In terms of a flow chart, again, we talked about there several different steps, and I'm not going to belabor you with these because you're going to hear from the judge in just a minute, but there's several different steps and several different types. But we do have this. If you are a landlord and you're interested in representing yourself, you can come down to our self-help center again, and we will provide you with a flow chart showing you the different steps needed and provide the forms for you for a de minimis fee. Again, in terms of the steps and the required forms, we break them down. This is actually a part of your packet, but we want to let you know, first of all, the statute that governs the eviction process. If you're going through an eviction and you're attempting to represent yourself, you must empower yourself to represent yourself. That starts with reading and knowing exactly what part of the Florida statute is relevant to the legal action. But the elements and what's most important is a landlord-tenant relationship must exist in order to be eligible for an eviction. We have a lot of, adult children still at home with mom and dad, and, they've never received any obligation from mom and dad to pay any rent because, of course, this is mom and dad. I've always been there. But if mom and dad wants you to leave, they tell you all the time, I could just kick you out. Not the case. So to kind of make sure you understand, there must be some type of bargaining. In order for you to stay at this property, you've either bargained for, a monthly rent amount and or in exchange for something to stay there. So that's very important. And we talked about the elements. Okay, so we're going to go into the different types in just a minute. But the forms needed, again, I told you we offer those and the judgment. So all of these forms and the elements and the statute, this is a part of our packet. So this is the part when we talked about the different types of notices relevant to an eviction process. 3-day notice. A 3-day notice is the notice that that is provided in the packet, and the notice that a landlord must serve upon a tenant for non-payment. A 7-day notice is one if there is some type of non-compliance of some sort, meaning there's a part of the lease agreement and you're in non-compliance of it, and I'm serving you a 7-day notice saying you either need to cure it or you need to vacate the property. And again, you must first give them an opportunity to cure whatever that violation is before you can actually serve them with something to vacate. And the last one is a 15-day notice when you just really and truly, you have a holdover tenant, and that holdover tenant may be on a month-to-month lease, or, and you don't have an up-to-date lease agreement. In order for that person to leave, you still have to serve them notice. And if that person is paying you on a monthly basis, it's at least 15 days. If they're paying you on a weekly basis, then it will be a 7-day notice. But again, at any given moment, if you want to evict someone, or if you are being subject to an eviction or threatened, you must first receive notice. Due process is certainly a part of this process. Again, when we talk about non-payment due to the pandemic, again, the 3-day notice, the next is the eviction complaint. A summons will be issued by the clerk's office, and that paperwork must be served by the sheriff's office. Again, if you receive an eviction complaint and a summons for non-payment of rent, you have 5 days to respond. 5 days. It is a summary proceeding according to the Florida statute, and you only have 5 days to respond. And let me just tell you, they have the right, if you are not there, to post a copy of that summons and that complaint on your door. So if you know you haven't paid your rent, you need to make sure you are monitoring this situation. The next is eviction complaint. The summons, if there is damages, if you owe back rent, and the landlord says, not only do I want you to get out, I also want the back rent that you owe me. That is 20-day summons. So you will have 2 different summons issued against you, a 5-day and a 20-day. You need to respond to both of them, and you need to do that timely. How do you respond? By filing an answer with the clerk of court for review by the court. You have 5 days to do that for a non-payment. And if there is, if you are being sued for possession and back rent or damages of some sort, you have 20 days to respond. But you must file a written answer, and a copy must also be served or mailed to the landlord so that the landlord will know that you have properly responded. If you need a copy of a blank answer form, because again, we're trying to empower people to represent themselves in court. And how you empower yourself is you talk the language that the court understands. So by filing an answer or responsive pleading, that's how you respond to an official eviction complaint. In addition to filing an answer, if there is an amount that the landlord is saying that you owe in order to, and the reason why they are evicting you is because you owe money. You need to come down, file the responsive pleading, and deposit the money owed into the court registry. If you look at the amount that's on the complaint and you don't agree with it, then you must also file a motion to determine rent with the responsive pleading, and the amount that you do agree that you owe, you must file that with the court registry. Now, in addition to the clerk's office being the official record keeper, we are also the court's official cashier. So by saying filing with the court registry, you would come to the clerk's office to file the money with the court registry. I know a lot of people just throw that terminology out there, and they assume most people understand what the court registry is. That means bring the money to the clerk of court. Okay. So, and the last, of course, you would go through your process, and the court will make a determination as to whether or not a final judgment and or a writ of execution, a writ of possession will execute against you. The writ of possession, again, is that last formality that we talked about that the sheriff's office will come out if a tenant has received a final judgment for an eviction and still refuses to leave and surrender possession back over to the landlord. That's when the writ of possession is actually entered by the clerk's office and will execute against that party. Now, we talked a lot about a process and forms and where to go. Now I want to tell you how much it costs. To file for an eviction, it is $185 to file with the clerk's office. There is a $10 fee for a summons to issue. So again, this is for landlords. $185 to file, $10 for the 5-day summons, $10 for the 20-day summons. So that's a separate fee for every summons that issues. If you have more than one tenant at the premises that you are trying to evict, you need to have a summons for each one of those tenants. The roommates, don't just do the household. You need to have all of them served. You can file one complaint, but have all of them served with that complaint. In order to have a writ of possession issued by the clerk's office, it is a $90 fee. And for tenants, to deposit money into the court registry, there is a court registry fee. It's 3% of the first $500 and 1.5% of all of the remaining. Okay. So those are just some tidbits. I want to make sure that everybody understands. Keep in mind, if the tenant prevails in the hearing and no final judgment is entered against that tenant and money has been released to the court registry, you can motion file a motion with the court for that money to be returned to you. Landlords, if money is sitting in the court registry and you feel that money is owed to you, you can also do the same. Make sure before you leave the hearing, the judge is up next, that you ask, what do I need to do to have the money released back to me, to make sure that that is discussed. So just really quickly, Eviction 101. A landlord may not threaten to evict a tenant for retaliatory purposes. You can't retaliate against a person just because they've done something that you don't necessarily agree with. You can only evict someone based on the terms of the lease agreement. If there's no lease agreement, you default over to the Florida statute. And we talked about that. Florida statute chapter 83. Okay. Landlords may not evict a tenant for having visitors. Hey, I don't want to see that person at your house anymore. Sorry. Now, if that person is causing trouble, that may be considered non-compliance, and so you might be violating the lease. But again, just because you have a visitor, that doesn't necessarily mean that you are subject to an eviction. Landlords should not evict a tenant just because the tenant has requested a code enforcement inspection. We see this all the time. That's retaliatory conduct. And certainly you cannot do it based on race, nationality, disability, gender, or religion. But a good eviction is if you owe money, if there's criminal activity or drugs, or if you've abandoned a unit for more than 3 months. Those are all opportunities. And I'm sharing these with you right now because we see a lot of landlords coming down to the clerk's office right now saying, how do I get this person out? And and we're having a lot of tenants come down saying, I can't afford it because of the pandemic. But the landlords are still trying to shop ways to have the tenant removed. So we just want to make sure everybody's aware of their rights. We're seeing a lot of security deposit issues. The landlord has 30 days to return the security deposit or to give you notice of an intent to claim that security deposit. If they don't do that within that time period, they waive the right to do it. Okay. Not only that, they must send that notice to you in writing by certified mail to that last known mailing address. So whatever that mailing address is, you make sure it's up to date because we see a lot of people, it's going towards the end of the year where the lease agreements are up and the landlord is refusing to renew them. I'm not going to go into the rent withhold, but if there's an issue on the premises and you feel like that you have a right to withhold rent, you can't just do that on your own. That's self-help. Those self-help measures don't work. You must follow a certain procedural process. And again, we have some collateral at the self-help center downtown to help you if you are interested in doing that, and that is for tenants. Lastly, there are a couple of different programs out there. As you know, the Eviction Diversion program is about to sunset towards the end of the year, but still, please do call 211, as we would always ask you to do, to find out other services and other programs out there that may be able to help you with some sort of crisis assistance. Certainly, Orange County has a crisis assistance program. We work with them with their EPIC program, which is eviction prevention. And last but not least, please just don't forget to communicate. If you need to notify your landlord and ask for an extension or to ask for some grace, please do that. A lot of the judges really want to know if you tried to reach out, if you tried to communicate before it gets to the point of legal action. So I'm saying if you see the problem on the wall right now, please go ahead and communicate. You know that you are receiving CARE Act funds right now, and you know they're getting ready to sunset. Please start talking today. Lastly, I just want to share with you where to go again. We at the Self-Help Center, we're so proud of what Clerk Russell has put together in terms of our Self-Help Center. We offer, in partnership with the Orange County Bar Association, legal advice through scheduled virtual attorney appointments online. I've given you the information. You can always call the Self-Help Center. Those appointments are Monday, Wednesdays, and Fridays between the hours of 8 and 4. And we, the Self-Help Center, are located on the 3rd floor in room 340 at the Orange County Courthouse. If you have any questions, if you're in need of forms, or you'd like to schedule an appointment with one of our attorneys, please contact us at the Self-Help Center. We would love to have you. Thanks again, Dane. This concludes my presentation.
All right. Thank you very much, Roberta Walton. So that is attorney Roberta Walton, who's also the manager of our family division and our self-help center. Great information. And again, if you're looking to make an appointment, possibly with the self-help center, you can visit our website and make those appointments right from our website, which is myorangeclerk.com. myorangeclerk.com. For those of you that may be just joining us, welcome to our legal forum with the Orange County Clerk of Courts. It's the evictions process. We're trying to give an update, of course, and we are giving an update on evictions in the COVID-19 environment. This is a recorded webinar, and as a reminder, you can submit questions to us through the Q&A function you see at the bottom of your screen. So far, we've had a couple of questions come in, and we're going to address those when we get through all our presentations. We'll have that Q&A portion towards the end of the webinar to answer any questions you've submitted. And again, we'll have a survey at the end of the presentation. So from here, we're going to move on to our next presenter. And up next, I have the pleasure to introduce the Honorable Judge Eric DuBois, who's taking time to share with us a perspective now from the bench. Thank you, Judge, for joining us tonight.
Thanks, Dane. It's great to be back. I appreciate the invitation. Roseann, good to see you. Roberta, good to see you, everyone. So as a county judge, we oversee all of the landlord-tenant evictions throughout Orange County. There are 5 county judges currently serving all of the citizens of Orange County, and we handle evictions. Historically, we would average around 1,000 to 1,100 evictions per month. And then obviously in March, when the coronavirus pandemic hit and the governor put the moratorium on evictions, we were very concerned about this tsunami of evictions that would have come about, which is why we were glad to work with Roseann and the mayor's office on this eviction diversion program. And, you know, honestly, it's been I think a blessing. The fact that we've used half of the money is a good sign that we've saved a lot of people and we've kept a lot of people in their homes. But as a judge, I can't give legal advice. So I want to thank Roberta for all of the information, free legal advice she gave you. And I know Andre is going to come and give you more free legal advice and answer some questions. But I just want to share with you all some of the numbers and where we are from the court's perspective. As I mentioned, where'd my screen go? Hang on one second, sorry. So as I mentioned, I'm one of 19 county judges, but unfortunately, we only have 5 county judges assigned to the civil division. As Roberta talked to you about self-help, I want to talk about that briefly before I go into the PowerPoint presentation. Self-help, I know, you know, some of you on this town hall are landlords. If you go in and just unilaterally evict someone on your own without the court's intervention, you're setting yourself up for attorney's fees. You're setting yourself up for a lawsuit. You can't just turn off someone's water to force the issue. You know, we see it, unfortunately, we see it all the time. Judge, I came home and there was a lock, my door locks were changed and all my stuff was on the curb, and there was a curb alert posted on Facebook and now half my stuff's gone. Well, guess what? You as a landlord are going to be on the hook for that unless you had a court order that allowed you to do that. And tenants, Roberta talked about, you know, if you get a summons or you get a 3-day notice, I would highly encourage you, if you know that you're behind in your rent or you get served with a 3-day notice, that is the perfect opportunity, if it's before December 16th, to start the process of the eviction diversion program. I know there's a question in the Q&A, and Dane, forgive me for jumping ahead, but Ms. Mars, I don't know the situation in your case, but if there's a CDC a certificate or declaration filed, it's on you to call that up for a hearing. The courts, when there's a CDC declaration filed, the courts historically would consider that what's called an affirmative defense. And based on the CDC guidelines, will put it on the landlord to question whether or not they want to make the tenant provide evidence that there is an issue. Dane, is there a way you can put up my PowerPoint? All of a sudden it disappeared from my screen. I don't know what happened.
Yes, we are
Sorry.
actually working on that right now.
And of course I updated it and now it won't show up. Let me see. So what Roberta talked about was there's a 20-day summons and a 5-day summons. So the 5-day summons is if it's just an eviction, and the 20-day summons if it's an eviction plus some other monies that are due and owed. So the CDC declaration that Roberta talked about must be filed within 5 days. On day 6, you're in default. On day 6, if the landlord comes before the judge and there's nothing in the court file, we have a lot of power, but one power we don't have is being a mind reader and being a fortune teller or, you know, psychic. We don't know what your situation is. If you come to us on day 7, it may be too late. If you come to us on day 6, it may be too late. So please make sure you get that CDC declaration in. So as Roberta talked about, and as you've heard, and I want to beat it into everyone all over again, the governor's executive order expired October 1st at 12:01 a.m. Everything then deferred to the federal Health and Human Services, Center for Disease Control administrative orders. Yesterday, the Health and Human Services and CDC extended the foreclosure moratorium. So if a landlord has a Fannie Mae or Freddie Mac loan, they cannot be, or you live in a Fannie Mae or Freddie Mac guaranteed mortgage, they cannot file a mortgage foreclosure against you as of right now until February 1st. Unfortunately, the eviction moratorium that's in place under the same CDC and Health and Human Services order, as it is right now, when we started this program, expires December 31st at 11:59 p.m. So at 12:01 a.m. on New Year's Day, if they want to file evictions, they're more than welcome to come file. Fortunately, it's a Saturday, so the courts aren't open, and there's some extra days that you're going to have. My guess is, and I don't know anything, and I don't have any secret word, is that if the numbers continue to go up and the numbers continue to increase, the federal government is going to extend that, at least to keep consistent with the mortgage foreclosure moratorium. And hopefully, as Congress on a federal level is passing more CARES money, more help and assistance, that the monies that we have to turn back to the state of Florida from the CARES money that we received from the first batch of money will be extended. But don't plan on that. Don't assume that. Get your applications in by December 16th so we can get you that money. I don't think there's anything that we'd rather keep the money here in Orange County and pump it into our local economy than send it back to Tallahassee to send back to Washington to, unfortunately, probably not come back to Orlando. So if you're a landlord and your tenant files that CDC declaration, that's on you to call the judge and set it for a hearing. Okay. We unfortunately, our judges have about 8,500 cases on their docket. And while we're charged with processing through evictions, we cannot babysit each eviction that's filed. We rely on the landlords to move those cases along somewhat. So if you want a hearing on that CDC declaration, we need you to move that CDC and call it up for a hearing. All of our hearings right now are being conducted the same way we're conducting this forum, all through Zoom, or by calling a 407-836 number and being put into a conference call. So no one's going to have to come to the courthouse for a civil hearing right now. Okay. Dan, if you can hit the next slide. Locally, we have an administrative order. It's 2020-11-04. That stopped evictions for the non-payment of rent, but that expired on August 1st because we can't go over and above the governor's orders, and we can't go over and above the CDC declarations. As badly as we want to, and as badly as we want to say no one can be evicted right now until, everyone's back to work and everything's back in place, we don't have that authority. We have to enforce the law as it's written or the executive orders as they come out. So unfortunately, right now, there's no administrative orders. Everything is as whatever the CDC and Health and Human Services orders are in place. Dan, if you can hit the next one. So this is old. I had updated it. So let me see if I can find my updated slide real quick. So evictions in the month of November were, in November of 2020, we had 710 evictions filed. When you compare that to 877 in 2019, that gives us some cause for concern that number is getting close to where we were historically. And I can tell you that in November of 2020, 222 writs of possession were issued. So a large number of these evictions are monetary in nature and are unable to be processed forward. My guess would be that for tenants, your landlord, if they filed this, as soon as that moratorium is lifted, is going to be knocking on the courthouse door to get those final judgments. So again, if you're in this category, why not reach out to the county and take advantage of that free money that we were given that would cover up to 4 months of your rent? December, this month so far, we're seeing about a 20% reduction in the eviction filings over last year. And last year there were 932 evictions filed in Orange County. So we're expecting roughly about, my guess would be somewhere in the 800 number. Evictions typically go down in December just because of the holidays and landlords don't want to necessarily evict people. I can tell you the courts are not fond of evicting families and telling them to pack up their Christmas gifts and take their Christmas tree. So there is a slowdown on the court's perspective and the court's end on the evictions, and it's just the nature of the beast. If you get the next slide. Thanks. So the role of the court, I wanted to talk briefly about that because we are blessed in Orange County to have the self-help center that Clerk Moore Russell put together and that Roberta so diligently runs and makes sure that it is clicking on all cylinders. The judges are to follow the law and follow the statutes and the administrative orders. We can't, as much as we want to be compassionate, as much as we want to feel bad for everyone, we can't, or we have to follow the law. And we can't provide legal advice. That's why in all of our courtrooms in the county civil division and outside the county civil courtrooms, we have the flyers for the self-help center, and we have the eviction diversion information, and we have it at the clerk's desk, because we want you to go get that advice. We want you to go get that appointment with an attorney in the self-help center, or Carl, our amazing legal aid division, the Orange County Bar Association, who will pair you with another attorney who will give you their time and talk to you about your program. If you feel you've been wrongfully evicted or you're a victim of self-help, call legal aid, call the self-help center. They can assist you and get you legal representation, typically and often at little or no expense to you, especially if you call legal aid. I know the self-help center charges a very fraction of what a normal attorney would charge you. Most important thing, and I touched on it earlier, is we can't guess what's going on. As Roberta said, you've got to file that answer. If you don't file that answer and a landlord comes to us with a final judgment, we're going to sign it, regardless of if it's just monetary or if it's monetary and criminal nature, or if it's monetary and just whatever, just being a nuisance. If we don't hear from you, we can't send people out to investigate what's going on. Bottom line, we need you to tell us what's going on. Is, the great poet or great philosopher Jerry Maguire said, "Help me help you," right? If you're going through a COVID related financial issue, you've got to tell us. We want to help you, and we want to follow the law as it is right now, but we can't guess as to what it is. So there's not much more I really can say, except for we appreciate all of the work that the county's done to keep everyone in their homes. We know what's going to happen, unfortunately, if this crisis gets out of hand. And that's why we were so happy to partner with the county and legal aid and the Orange County Bar Association. And if you have questions, go see my good friend Roberta. She'll be happy to talk to you. Call Andre. He's about to give you some great legal advice. But all in all, from the court's perspective, we appreciate everything the landlords are doing to work with the tenants. I know I serve on a couple boards or groups because of this, and I know the apartment associations are really working hard to work things out with tenants. So if you're a tenant and you are struggling, my guess is, from talking to a lot of the landlords, something is better than nothing. And if you bury your head in the sand, they're not going to work with you. If you rent $1,000 and you can come up with $500 a month, go talk to them. They'll spread out that other $500, because the odds of them finding someone else to take your spot in that apartment that's able to pay that rent is right now, unfortunately, is going to be very difficult. So the landlords I've talked to have said, "Judge, I'd rather have someone that I know that can pay me something and we can work it out on the back end than start from scratch and possibly have an empty unit for 6 to 8 months." So with that, Dane, I appreciate it.
All right. Thank you, Judge. We really appreciate you. So thank you, Judge Eric DuBois, for sharing his insight with us. It's always, to me, I just think it's amazing treat when we have a judge who can share information like this. So we appreciate the fact that you're with us, sharing great information from a bench perspective. All right, so now, and we've been getting some questions rolling in. We're going to try to get to those here shortly. Again, the Q&A portion at the bottom of your screens where we're taking questions. We'll address those here very shortly. But our last panelist to give us a little bit more insight is we have a local practicing attorney with a legal perspective, Andre Young, who is with the Paul C. Perkins Bar Association. Andre.
Good evening. Thank you, Dane. And certainly thank you, Madam Clerk, for putting this together and thinking enough of me to invite me. I am here at the bequest of the current president of the Paul C. Perkins Bar Association, which is Jared Brooks. I don't believe that organization is currently doing anything with regard to ongoing assistance with landlord-tenant issues, but I do know that that is a website that you all who are watching should look into, because they very often do seminars like this, and they are constantly offering free services and workshops for the community. Unfortunately, I've got the headache of going last. I mean, they have really taken all of the thunder that I could possibly have in presenting this evening. But I do want to reiterate on some things. And I think because of the fact that the clerk's office can't give legal advice, Judge DuBois can't give legal advice, Roberta and I are the only ones who are going to really be able to answer questions, I guess, as well as the chief of staff for Mayor Demings. She may be able to answer some questions, but I think that's why they had me last, so that I'm first up to answer some questions. But like I said, I would like to reiterate some things. First and foremost, it is essential that landlords and tenants understand how important documentation is. Judge DuBois doesn't know any of you when you come into his courtroom. All he knows is what you can present to him. So if, as he said, if you've got a CDC affidavit, you need to have that. You need to make sure that you're following those protocols. As Mrs. Harrington said, documentation, it's unfortunate we live in a day and time where we can't take people at face value. In order for you to get any assistance, you're gonna have to provide proof. You're gonna have to show that you're out of work. You're gonna have to show that you had some hardship. You're gonna have to provide the CDC affidavit. And so you need to have those things. And to piggyback again off Judge DuBois, communicate. If you talk to your landlord in writing, again, we're talking about documentation, because he said, she said is completely useless in the court of law. If you don't have an email, a text, a letter, things to show what you've done and that you've done them timely, then it's really not going to do you any good to even come presenting those arguments, because it's just impossible for the court to evaluate the truth of it. So document, communicate early and often. I know it's a difficult situation if you aren't able to pay your rent. Certainly if you have other people in your household that depend on you. However, it's an even greater travesty if you stick your head in the sand, as Judge DuBois said. You have got to get out of your own way, get some help, call somebody. Self-Help Center is a phenomenal opportunity. Legal Aid Society of the Orange County Bar Association is, I don't know that it's better, but it's cheaper. And I don't know that anybody's provided their number. Their number is 407-841-8310. Call, get some help, get some guidance. Don't ball up, don't roll up in a ball, because you are going to end up being in a worse situation and not be in control of when things happen if you are unresponsive and don't really engage and get in front of the situation. And landlords, the same for you. I know so much of this is really kind of geared towards tenants, but certainly for those mom and pop landlords who own rental properties, we have a lot of here in Orange County, Florida, because it had been a great place to be a landlord, short-term rentals and what have you. But you need to document as well. If your tenant calls you, tell them to send you something in writing. Tell them to provide you with proof that they've been laid off, proof that they've applied for unemployment, proof that they've applied for some of these governmental benefits, and so that you know that they're doing everything they can and to help them, so that you can maybe be a little more forgiving or a little more flexible if you see that they're putting their best foot forward. Let me see what else I heard that I just felt like I hate they said it, because I wanted to say it. Documentation, communication. I'd like to reiterate again, because Roberta did an amazing job in her section, basically going through completely how the legal process works. But a lease is a legal contract. You have not heard anybody say on this call tonight that there is something that they can do to completely absolve you from having the responsibility of paying rent if you're a tenant. That is, the government has not done that, cannot do that. They can hold off, but the money you owe under that contract, you are responsible for. And so be very, very mindful of that. That these are things that are going to maybe help you stay longer. It is not going to make that rent disappear. And so, as Judge DuBois said, a partial payment goes a very long way. Certainly if you see yourself as an appreciative tenant, you understand nobody can stay anywhere for free, that there are taxes and often mortgages and what have you associated with the place you're staying in. Do your part, pay what you can, and understand that whatever you don't pay at some point is going to come due, and you're going to be ultimately responsible for that. I just think that has to be said over and over again, because I hear all the time people thinking that there's some program, they hear self-help in Orange County, $6.5 million, they're going to pay back rent. And once whatever amount they pay from that point going forward, you're going to be responsible for what you accrue after that time. As Roberta said, and Judge DuBois said, I just want to say it again so you all can have it in front of you. Take the time, if you are facing this issue as a landlord or a tenant, and read for yourself Florida Statutes Chapter 83. It's one of the more digestible statutes of the Florida statutes. And it's because it's obviously an area where we have a lot of people that are impacted by it. So I would highly recommend you take the time to read it yourself, but don't read it and think that now that makes you an attorney or some sort of legal expert. Reach out to OCBA, go into the self-help center, call an attorney. A lot of attorneys are really, really understanding what's happening out here in our community and have a heart for people in the service, and they talk to people for free. I can't afford to do it all the time, but I do it far more now than I did prior to the pandemic. So go through the yellow pages, call till you get somebody who will talk to you if you aren't able to get through to the self-help center, or OCBA hasn't gotten back to you and you feel like you're in dire straits. Call somebody and see if they don't do it, maybe they can tell you somebody who they think will speak to you for 10 or 15 minutes just to kind of talk through what the issues are and what they would advise you to do given those facts. And that's about it for me. Like I said, I know I'll be hot and heavy during question and answer because so many of the presenters tonight, due to ethical reasons, are unable to give legal advice. So I'll be here to try to answer questions that may even have been pitched to them on their behalf.
Great. Thank you, Andre Young, who is with Policy Perkins Bar Association and a practicing attorney. Good legal advice. So yeah, we're going to jump in and get to the questions because we've had few of them rolling in here. We might get more as we go along. So for this portion of the webinar, we are going to answer questions you all have sent in. And if you have any other questions, remember you can submit them right there at the Q&A box at the bottom of your screen. So go ahead and submit those at this time. As a reminder, you may ask a question using that portion, and we'll continue to answer them as we go along. So this first one that we had was not really a question, but it's good information. So I'm going to share it, which is to tell people to contact legal aid, as we've had some of our panelists say. Contact legal aid for assistance on defending their eviction case or for an illegal lockout or any prohibited practice. So legal aid is definitely a resource. Also, they are sharing that the Florida Eviction Answerbuilder.org is a great resource. That's Florida Eviction Answerbuilder.org. I don't know if anybody has, any of our panelists have anything more to share on that. If you do, go ahead, or we'll just move on to the next one.
Dean, I also wanted to share because we have these flyers delivered to the Self-Help Center from the Virtual Hawkins Fellowship. The Virtual Hawkins Fellowship is offering free legal services. So they've received funding to provide free legal representation for any COVID-19 landlord-tenant matter. And they are making those matters a priority. And so I have a phone number here. It is 407-982-6522. 828. And I also have an email. I'll be more than happy to, if you want me to share those in the chat room or something. But again, those flyers can also be obtained from the Self-Help Center, because they actually came in for a visit to say we are providing free representation and we're making the eviction COVID-19 matters a priority right now through the end of the year.
Okay.
Okay.
Great, good information. Thank you, Roberta. So the next question we have is, how many evictions were filed in Orange County per month since COVID-19? So, Judge DuBois, I know you had wanted to answer that question or have some insight. Of course,
So-
we have filing numbers here at the clerk's office. We could provide
Yeah.
somebody if they need the actual data, but go ahead, Judge.
Yeah, so just, and again, I would encourage whomever is asking this to contact the clerk's office for the specifics. But just for conversation purposes, in February of 2020, prior to COVID, before us knowing anything, we had 868 evictions filed. In January of this year, we had 1,101. March, obviously COVID hit us mid-March, we had 486. And then the moratorium went in place. April was 50. And then it didn't ramp back up to triple digits until really July. So we've had a huge drop off in numbers, which is why we know there are people out there that need help. We know there are people out there that can take advantage of the eviction diversion program, and which is why the mayor tasked Roseann with putting together this program and getting all of these stakeholders involved. Was we want to help everyone and we wanted to help people. So, the numbers are dramatically down prior to September, or prior to August of this year. But when you look at what could have been, the numbers are really amazing. I mean, I can tell you that from a judge's perspective, we have plans and procedures in place for when the moratorium is lifted, that we will be able to work with the clerk's office to process as many evictions as possible. Keeping in mind, there's 5 of us, there's a number of clerks, and there's only so many process servers and deputies that can serve civil process and do the writs and all of that. So it's going to be a slow roll, and we just ask people to be patient, which is why we encourage more people to work things out than go this legal route.
Yeah, as we were discussing earlier, Judge, it has basically been about a 20%, 18 to 20% drop off in eviction filings right now, October, November, compared to the same time period last year. And, some of the thought might be the reason that we have fewer filings right now is because hopefully of the diversion program and the moratorium and that sort of thing. So definitely, yeah, go ahead, Judge.
But in like May, June, July, it was more like 80% down versus, it was the opposite. So it's those numbers that we were really concerned about when we started the eviction diversion program. So I think, a lot of people were doing the right thing and paying the rent and able to use some of the extra money that we got from the federal government and the unemployment benefits and all that. And my hope is that it's just not as bad as we once imagined, but I'm afraid, based on what I'm seeing is landlords are getting creative now in ways to evict people that are non-monetary in nature. So.
Gotcha. Okay. All right. One of the other things I wanted to point out is we've had some questions related to getting the slides from these presentations. So I wanted to share with everybody again, this is being recorded. So our webinar is being recorded, and then we take this and then we will upload it to our website, the Clerk of Court's website, myorangeclerk.com. So you'll be able to look at the presentation again, see those slides, have those there. There was also a question if somebody could get the slides or the PowerPoint in Spanish. We don't have it in Spanish, so it's not translated at this point. Next question we have, this is from somebody saying, we received funds from the diversion program, but the tenant still has not paid any rent at all. The paperwork said the funds covered the rental period from April 1st, 2020 through the date the agreement was executed, which was September 16th, 2020. Roseann, I think you have possibly an answer to this.
Yes, I do. And so actually, you've met the requirements for the eviction diversion program was that both the tenant and the landlord agreed. The landlord agreed not to evict 2 months for the period of 2 months after they received their payment. And the tenant agreed to pay their rent and that they had the ability to pay rent. So, so it seems to me that this tenant has not lived up to their side of the bargain, and the landlord has, because if you got your funding September 16th, you were just had to not file evict through November. And you can't reapply for this program. So the tenant really, they've had their arrears paid off. So you've met your obligation at this point. So you no longer are under constraints of the eviction diversion program. So you can proceed how you need to proceed in order to get payment. That's from our perspective. We were just requiring that the landlords don't evict for 2 months after they receive the arrears are paid off for.
Okay, hopefully that answers that situation. The other question I had was December 16th is basically the cutoff, is the deadline, correct? Is there any chance that it could be extended, or that that could go beyond that date?
It depends on the House. The Congress is looking at another stimulus bill. And the problem is right now, the CARES Act funding, which we used to pay for this, Orange County received $243 million in CARES Act funding. And we've put well over 3/4 of it back into the community for rental assistance, eviction diversion, business assistance, small business assistance. But the deadline to spend that money is December 30th of 2020. If they come up with another stimulus bill, we're hopeful that they extend the deadline past December 30th. And then that way we'd be able to keep the program going. As long as they, in addition, they would have to do more funding for state and local governments. That is our hope. But for right now, the only way that we can use that money is if we have it spent by December 30th. And that's why we chose the December 16th date, because it takes about 2 weeks by the time you apply, if you have all your paperwork, and we can go ahead and get the comptroller, the documentation to cut the check.
Okay, good information. All right, next question we have, assuming no further eviction moratorium relief after December 31st, what is the expected or typical time frame for an eviction that is filed but stayed between FJ and writ of possession order for a holdover? Is the Orange County Sheriff's Office the only entity that can serve a writ of possession?
So I can try and answer that. If there's no moratorium after December 31st, all of those evictions would become ripe January 4th, which is that first Monday after the new year, which is when the courts reopen. Typically, if a landlord comes in with a final judgment, when they go to the self-help center, Roberta will provide them also with a writ of possession for them to have the judge sign at the same time, so they're not making 2 trips to the courthouse. And we have procedures in place for if that does happen, where people will be able to drop off their final judgments. You drop them off with 2 self-addressed stamped envelopes, and we provide those to the clerk's office, and they will send off what are called conformed copies of the writ of possession and the final judgment. And then you need to take, or certified copies of the writ of possession, and you take that to the sheriff's office, and they would then execute the writs of possession. I do not believe civil process servers can serve writs of possession. It's only the sheriff's office. And my understanding, the last conversation I had with the sheriff's office, they have 10 civil deputies designated to do civil process. So theoretically, if we have 4,000 evictions and there's only 10 of them to serve them, it's going to take a while, unfortunately. And with regards to the other half of that question, which was writ of the delay, there usually should be no delay. The final judgment get signed and the writ of possession usually gets signed simultaneous. Roberta, I don't know if you want to add anything.
Well, and you're absolutely correct. The final judgment usually has the language in it that a writ possession shall be executed. However, there is a process of coming down to the clerk's office and paying that $90 fee, and having it issued. And so you come down to the clerk's office, we issue it, and then you actually pay the $90 over to the sheriff's office, not us. Let me make that assertion. You're not paying the clerk's office the $90. It is to the sheriff's judicial process office, and that office is actually co-located in the courthouse as well, on the second floor in room 240. So if you come down to the courthouse, you can pretty much handle all aspects of everything you need to handle in terms of the self-help centers in room 340. And of course, the civil division is room 350. And on the second floor is the civil process unit for the sheriff's office. And you are correct. A process server cannot execute and serve the writ of possession. It must be the sheriff's office by statute.
And if
Hey,
I
Dan-
may,
Dan, I've got to run. Sorry. It's been a pleasure.
No problem. Thank you, Judge. Thank you
Thank
for
you,
joining
guys.
us. And Andre, I think you had a follow-up to that.
I did. I just wanted to piggyback. As Judge DuBois said, there are currently only 10 civil officers in that division, but as Roberta said, there's a fee associated with that service. And so if the authorities find that, hey, there's a bunch of revenue coming, they have every right, and if they are administratively sound, they're going to add staff in that area to get that glut. So don't get a false sense of security by Judge DuBois saying there are only 10 people in that division. That's as it stands now. If the floodgates open, I promise you, the sheriff's office is going to divert staff in that area to make sure that they're able to handle that caseload.
Gotcha. All right. Thank you. All right. So we have another question here. My eviction case. Oh, we lost it.
Oh, I'm sorry.
Oh,
I want you to bring it back up. I do want you to bring it back up. I did type a response in there.
Okay.
But,
yeah, go ahead.
But I wanted to share with the person, and I believe the individual basically said, you know, hey, I have been, my eviction, there it is. And it's Chick. My eviction case started on June 8th, still pending. The judge always busy. We both are sending documents, but did not hear from judge. And so what I did was I shared with this individual a copy of the website to take you to the Ninth Judicial Circuit's calendaring application. There is an online calendaring application, and that application is so informative because it gives you very specific directions for each individual division. So whatever division you're assigned to in terms of the judge that you're trying to get in contact with, my recommendation is you go to that website, go scroll down to that division and see what are the specific instructions that that judicial officer has asked you to follow. Because some of them are, you know, email me, some of them are call, some of them are, here are the only time slots that I have available. And how you communicate, again, we talked about the whole terminology in terms of empowering yourself. If you are attempting to represent yourself, people always come in and say, I'm trying to represent myself, but I don't have a lawyer. And my response to that is, you are your lawyer. If you are attempting to represent yourself, which means you have to find out how to follow the same course of actions that we have to as practitioners, to talk the talk that the courts understand. If you are interested in filing and getting a hearing and getting in front of the court, you file a motion and you ask the court for a hearing. And you have to work with the other side for their availability. So you have to communicate with the other side. There's no blocking them out. And you need to follow the court's directions on how they want to communicate with you and how they receive collateral and request for hearing times. And so you can go to this app, Chick, and follow suit so that you can find out, and bring anybody else out there listening, going to the Ninth Judicial Circuit's website so that you can find the specific directions on how that judicial office wants to handle scheduling hearings.
Okay, thank you, Roberta. Yeah, so we have, I think, 10 more questions here that have been answered. So some of these questions Roberta has helped to answer via computer, via typing answers in. But I like going through these if we can, so that verbally everybody else who's listening and attending
Right.
can get that information. So the next question we had that Roberta answered was, I have a tenant who just started her 6th month of living in our unit without having paid a single dollar, filed for an eviction on November 17th. Tenants fighting us, no word from the judge as of today. Where do I go from here? So Roberta, you then said,
I told her, Ms. Mars, you have the right to file a complaint for eviction for non-payment of rent if the tenant has not paid rent. However, should the tenant file a CDC declaration stating he or she cannot pay due to COVID-19, the court may not enter a final judgment of eviction without additional factors being considered because of the moratorium. And I, within my presentation, I talked about all of the elements of going through that CDC moratorium. The CDC moratorium gives landlords the right to request written justification, even though there's a written declaration filed. As a landlord, you have a right to say, well, show me written proof to justify it. And so that little element is in there, but I would ask anybody, and in here, my response is, if you have not done so, please review the elements online to determine if there is additional relief available, because there's tons of information out there relevant to the CDC moratorium. I recommend going to their website, reviewing, going to Legal Aid Society of the Orange County Bar Association's website, and some of these other, self-help websites for individuals that are seeking additional information. It's lots of it out there. Again, we have some of this collateral in the self-help center at the Orange County Clerk's office, but there is that one little key element, because all it says is file the CDC declaration. Make sure the landlord receives the copy, and if there is an eviction already filed, you need to include a copy of that declaration with your responsive pleading. But a landlord, you have the right to ask for justification.
okay. Next question we had, another one that was answered. This attendee said, only found out about tenant's response online. She did not supply us with response to 5-day notice, nor did she send us notification that she signed a CDC declaration with the judge. And Roberta shared, as she stated in her presentation, a copy of the declaration must be shared with you by the tenant and filed with a responsive pleading. And if you believe the tenant has not followed the steps as noted, then we recommend you request a hearing with the court. Okay. Next question that we had. At this point, what funds can we try to recover? Roberta, you want to share
Right.
your answer on that one?
And what I shared with this particular party is, I recommend you review the agreement you entered into with the county's diversion program, and thereafter you may be eligible to recoup funds owed after the CDC moratorium ends. Keep in mind, another entity asked about, what about outside of the filing period for the moratorium. Again, the CDC moratorium kicked off September 4th through December 31st. The governor had a moratorium from March through October. So if you're talking about periods outside of that, then you could still include it. And I don't think either the CDC moratorium nor the governor's executive order prohibited you from collecting the rent owed pursuant to the lease agreement. You just cannot evict during that time period. The amount owed remains the same. So keep in mind, you just need to to keep a running record of how much you're owed. And if you have recouped dollars from the county's diversion program, that is considered rent owed to you from the county. So you're going to have to deduct that amount from the overall amount owed from that running record that you're keeping of non-payment.
And to pick again, documentation, as Roberta is saying.
Absolutely.
As a landlord, you are going to be held accountable if you don't make those deductions, and your tenant is aware that they have these legal rights violated and go out and hire an attorney. You could see some very severe penalties in the realm of attorney's fees awarded by the court if you haven't kept your paperwork in order and given the tenant everything that they're entitled to.
Okay, great.
That's very important because I keep hearing, well, I received money from the county or the diversion program, but I haven't received anything from the tenant. Keep in mind that money is on behalf of the tenant.
Okay, great information. Next question we had, and Judge DuBois answered this one. The question was, in light of the fact we're experiencing a pandemic, has the court considered waiving the stipulation of this tenant having to deposit overdue rent into the fund? Seems like an impossibility since the tenant's being evicted. Judge DuBois' answer was, this is not something the court can just waive. It's statutory, and the responsibility can only be waived or lifted by the governor via an executive order or the legislature by changing the statute. All right. And we have reviewed it. However, the money we received didn't cover the full amount of the rent from April through September. Can we only try to get funds starting from September, or can we also try to recover some of the overage not covered during the covered rental period?
So I think they're talking about, I'll take the first part of this, is that with the eviction diversion program, we had a cap of $4,000. And what we said was that the landlord would pick up the rest of the fees. So they settled. So they have a workout agreement that says that they covered, that the period of time was covered. So let's say they went from April to September and they owed, and they were capped at $4,000 and they really owed $5,000 or $6,000. The landlord, when they signed that workout agreement, said, that's it. We're good. We settle. We have settled this case. I don't think, and you have Roberta and Andre here that can answer that further, but our attorneys felt like once they settle, they can't come back later and ask for any more funds because there was already a settlement for that period of time.
And again, that's the reason why I noted in the response earlier that I recommend you review the agreement that you entered into with the county as it relates to the diversion program. Now, keep in mind the CDC moratorium or the executive order, neither of which waive the amount of rent owed pursuant to the lease agreement. However, if you enter into an agreement, i.e. through the county's eviction diversion program, you just need to make sure you read all of the terms that you're agreeing to.
Absolutely. If you sign a settlement and that's a binding agreement, you're going to be held accountable for what you signed. And that's right. The logic behind that is you're getting something you would not have gotten had the government not stepped in and provided this benefit. So you've got to put some skin in the game and not get everything you would have gotten in order to get something.
Okay, thank you very much. Good information. Good answers. The next question we had, and this was a simple one, how do I request a hearing? So a hearing can be obtained through working with the assigned judicial office by filing a motion for a hearing and working with the other party for their availability. And Ms. Roberta also shared, please feel free to come to the Orange County Self-Help Center, room 340 of the Orange County Courthouse to retrieve a blank form for additional assistance. Right, Roberta?
Absolutely.
Okay, I think we're down to possibly our last question. And if you do have another question, make sure you submit it there in our Q&A portion before we finish up here. So we're down to final question at this point. Thank you so much for putting, Well, so thank you so much for putting this extraordinary webinar on and for taking time to answer everyone's questions and concerns. With the Office of Representative Carlos Guerrero Smith, we would kindly send you okay, so they're asking for a copy of the presentation. Certainly we can try to get that to you. Also, we've been sharing with everybody that a simple way to actually view this webinar again and the presentations you've seen, we're recording this entire webinar and it will be uploaded to our website, the clerk's office website, and we'll be posting it to our social media channels in the next couple of days. So you can look for that and you can replay the webinar right from our website, and the website is myorangeclerk.com. All right, any other questions? Okay. I think we're through most of it. Our panelists have any closing thoughts? Oh.
Carmen Torres is asking, hi Carmen, she's asking for legal aids number again, Andre.
That number again is 407-841-8310. 407-841-8310.
Okay. Well, if nobody, if our panelists don't have any more information to share, then we have gotten through all the questions. And so we thank everybody for joining us tonight, and we thank our panelists for taking the time. Hopefully you found this information that was provided helpful to you. Also want to reiterate that Orange County Clerk of Courts, our clerk, Tiffany Moore Russell, understands the importance of these conversations in our community. This is all part of her priority to provide more access to justice in our community. We hope the topics discussed were helpful, and a big thank you again to our panelists for joining us as we navigate through this process. Once posted, you'll be able to view this video again at any time you'd like directly from our website, social media platforms. As always, make sure to follow us on Facebook, Instagram, Twitter, LinkedIn to get the latest updates from the Clerk of Courts. And as we mentioned at the beginning of the webinar, we have a short survey that will appear on your screen once we're done here. So please take the time to fill that out. It's not too long of a survey. It gives us information, provides us feedback on what you thought about this session, other topics you'd like to see. And that helps us as we move forward to try to, again, provide more legal information, access to justice to our community. We really appreciate everybody for joining us tonight. Thank you and have a great evening. Bye, everybody.